Okay. Hello. Good afternoon, everyone, or good evening, or even good morning. Who knows where we all watching from? The first of all, we are sorry for the delay. We had some technical problems, but now we are on, and we're very happy to be with you. So, thank you first of all for attending this panel at ICAIL 21, which will start now. And first of all, before we move ahead, I'd like to thank the organizers for the opportunity and for the debate that we hope will follow. We hope we will start by bringing this on this up today. To start with, I'll pass on the word to Carla, which will be the moderator. Carla is a long time um, worker and researcher in copyright. She's a musician, she's a DJ, and she has a long history on the music history in Brazil, on the music industry in Brazil. So, welcome and thank you very much, Carla, for being together with us in this endeavor.
Thank you. Thank you all. Thank the organizers. We are presenting the copyright workshop about copyright regulation of inputs and outputs of AI systems. For this, we have amazing and awesome researchers that I will introduce now. Professor Sean Flynn, thank you for being part of this. Miguel Bastos Alvarenga from Federal University of Rio de Janeiro. Professor Lucas Chiru, Brazilian Copyright Institute, NUREC. Luísa Cruz Lobato, PUC-Rio. Anies Canut, University of Warsaw. She's not here. She will be soon. And Professor Alain Rocha de Souza, from ITR, UFRJ, PPED, UFRJ, e NUREC. Professor Sean Flynn, thanks for being part of this. And I will introduce Professor Sean Flynn is Director, Program of Information Justice and Intellectual Property, Editor-in-Chief, Infojustice.org, Chair, Global Expert Network on Copyright User Rights. Thanks for being part of this, Professor.
Thank you. Thank you. It's great to see you all today. Can you hear me? My audio is a little bit funny on my side, but okay, as long as you can hear me. It's great to be with you all today. It's a little strange being at the University of Sao Paulo from my own office, and it's quite frankly not as fun, but I hope in the future we can get together actually personally. But this is a very exciting topic for all of us. It's also wonderful to be here with two of my future students, Luca and Miguel, who will be coming to visit us soon. And so for you guys, this will not be graded or counted in your efforts in the future. But of course, everything will be influenced. Let me try to share my screen, and I want to talk a little bit about the role of copyright in the inputs for artificial intelligence and text and data mining, and I know some of my colleagues are going to share aspects of other parts of the problem. So let's see if I can make this work. Okay. Yeah, is it showing? It looks like it's showing to me. Okay. So the approach that I take to this issue is actually focused more on the concept of research than it is the concept of artificial intelligence, but creating artificial intelligence programs does require a type of research that can be authorized by copyright. And that becomes the major question in this part of the area that I want to discuss, which is when and how does copyright permit the training of artificial intelligence applications with material that is itself copyrighted? So just to begin, let me start with two kind of practical or policy problems. The first is, what can AI do for us? And so to pick just one example that's currently of interest to many people, which is that artificial intelligence applications can be used to track viruses. So it was an artificial intelligence application based a for-profit firm located in Canada that originally first discovered the path of an emerging virus and its spread between countries. And the way it did that in part was to digest thousands and hundreds of thousands of news articles, copyrighted products, and compare them with other documents. Some of them are copyrighted and some not in different parts of the world, things like government's reports and health information, information about volumes of plane tickets and such, and took all that data and combined it into first it downloads it and copies it and puts it into a huge computer database and then uses an algorithm to try to find correlations in that database. And it was that firm's asset that ultimately discovered this emerging virus, which now is known as the COVID pandemic. So that's one possible utility. And then another policy question that again points to a copyright issue. So the copyright issue in the first one is, can you make those reproductions? In what countries are you permitted to make those kind of reproductions? Can you have a Canada-style COVID detector? So that's kind of the first policy question. The second policy question is, are those systems, whatever you create, whether or not you can create them, so if you're in a country where you can create those systems, are those systems biased? We've got many examples, some of which you may have heard of. For instance, a self-driving car that doesn't brake for a kangaroo because it doesn't know what a kangaroo is. It's only been fed data from the US or maybe Europe where there are no kangaroos. And so the car doesn't brake for a kangaroo. Or what about language identifiers that take the phrase, I am a black woman, and identify that as a negative statement because it's reflecting the bias that it reads within the text that it is mining. Or a language identifier that equates man is to computer programmer in the same way that woman is to homemaker. These are all actual examples where bias is reflected in the outputs of an AI program, in part because bias is reflected in the inputs. So how do we train machines? We train machines by inputting through reproductions large, huge, massive amounts of information into these programs that can then be mined and analyzed. And you need as much information as possible. If you only take that information from biased or selective locations, then that bias or selectivity is going to be reflected in the outputs. So the first question is around, can you even make these tools? And the second question is, how do you make sure that the tools are themselves doing what you want them to do? So both of those raise copyright questions. So in copyright, we talk about two different but related rights which a copyright holder can have. First one, the oldest one, is the right to reproduction itself. Can you make the copies of those news articles that allow the Canada virus detector? So that's the right of reproduction. But then the second, to control bias, you need a different right. You need the right to share, the right, what we always often call it as communicate, the right to communicate, or sometimes to distribute, or to make available those same copies to another researcher or teams of researchers, etc., to promote validation, to look under the hood. So in order to have first the tool and then to correct the bias in the tool, you need both the right of reproduction and the right of communication. So where do you find those rights? You often find them in limitations and exceptions for research. So when does your copyright law allow a communication or a reproduction of a copyrighted material like a news article in order to first use that to create the machine, and then second, the communications that are required to validate the data within it? So one way you can get there is what we call open general exceptions. So this is like fair use in the United States, for example, but there are other versions in different places. I show, for instance, Singapore and Thailand on the screen here, which have open, general, flexible exceptions, which allow you to use, which means both reproduce and communicate, use content for multiple different kinds of purposes as long as it passes a balancing test. So these kind of rights may not specifically mention text and data mining or creation of artificial intelligence or even research. They often do, but they don't have to. But they turn on a kind of balancing test that can permit those uses. So it's less clear, less certain in some respects than a specific authorization, but you can often at least have an argument if you're a researcher that what you do is permitted under such an exception. A second kind of exception would be a more specific research exception that focuses on research itself and then authorizes the kind of uses that are necessary under that research exception. So here you're looking for a couple things. You're looking for, does that research exception apply to all kinds of works? By all kinds of users? Can anybody make that reproduction? Does it apply to both reproduction and also communication? So reproduction, the making of the database, but then communication, the sharing of that database as necessary to promote collaboration or validation, etc. So on the exceptions I'm showing on the screen now from the EU, from Switzerland, France, they only extend that exception to reproduction, not to communication. So you have the permission of creating that Canada virus detector, but not the sharing that is required to prove whether that Canada virus protector or whatever it is unbiased, because you don't have the right to share the underlying content with other researchers, etc. Another class of exceptions that are more problematic only cover certain kinds of works. So in this example, in Russia, for instance, you could create the Canada virus protector the way I described it. Individual articles can be copied for a research purpose, but not whole books. So you can have the newspaper mining program, but you can't have Google Books, which takes reproductions of entire works and allows text searching of those works. So that's going to aggravate our bias problem. So you can search full text books in the United States under Google Books, but there isn't a similar repository of Russian language sources, and there won't be under Russian law. And again, examples from Peru, Hungary, and other places. I always include this example from Hungary because I think it's interesting and kind of points to some of the problems with not updating our copyright laws with the times. You see, in Hungary, you can make a copy of a whole book, but only if you make that copy in handwriting or with a typewriter. You know, two mechanisms that certainly don't help the cause of text and data mining or even of research very closely. And finally, here I flag in red to caution you against these kind of exceptions that only extend research exceptions to the use of excerpts or quotations. And so here text and data mining is really not possible at all, even more restrictive than the Russian example, because to do text and data mining, which is the kind of functions you need to train artificial intelligence, by definition, you need to be searching for whole works. You can't just feed the machine quotations. You need to use whole works. So in these areas, at least on the face of the statute, we can have an interesting conversation about where Brazil is in their case law, but on the face of the statute does not extend to the kind of research uses that we would need for these kind of modern research examples. So those are the examples. This is what the map of the world looks like. Only in the green countries do you have reproduction and sharing rights to both produce the tools, but also permit the validation of those tools and combat bias in these ways. And so if you look at that map, only in those countries can you extract all the data you want. If you're only going to be working for those countries, you're going to have some obvious bias. There are very few Spanish-speaking countries or Portuguese-speaking countries in that mix, for instance. There's entire parts of the world that are essentially screened off from collaborating in this way. And so if you have a project that is truly global, you're going to need a fairly sophisticated copyright analysis to decide where and what you can do in different countries. And it's this global copyright analysis that really shows where a lot of the problems are today. That we bifurcate and separate and fragment the authorization to do research between countries. What rights you have as a researcher is radically different depending on the soil in which you're standing. So one of the pieces of our research is to look at whether that has any effect. Does it matter which country you're in? And the answer is demonstrably yes. So my colleague Mike Palmetto, who's the economist at PIDGIP, has been doing empirical analysis and econometric analysis to control for various factors and look at whether having a more open and accepting research exception is correlated with the production of more research. And what he's finding is documented in that chart at the right, that there's a very clear correlation between having more open research exceptions and the production of more publishable research from the researchers in those various countries. And he controls for GDP per capita, population, other factors to try to isolate whether the research exceptions appear to have a demonstrably effect. And so far in this initial research, we're finding that they very much do. So that's a description of essentially the problem. So we have a problem with this fragmented copyright systems. It prevents researchers in all countries from either creating that research tool, that artificial intelligence tool, or participating in the validation of that tool, which is necessary to test bias. Only in some countries do we permit that. And so then the question becomes, well, what's the policy hook? What can we do about it? So one recent paper that I just want to reflect upon, I've cited it here. You can find it in open source, in an open source repository at American University, for instance, and it's published in a couple different places. Looks at one element, which is what international law might be able to do. And so our proposal there is to look at the most recent limitations and exceptions treaty that was passed out of the World Intellectual Property Organization. And specifically to look at the Article 5, which is the cross-border use provision, as being a simple and potentially very effective tool to combat some of these problems, which is to say that any research corpus, any research material, like a material for people that are visually impaired, to allow the cross-border use of that material where it was lawfully created in the first country. Then you could at least have collaborations between researchers in red or yellow or blue countries and researchers in green ones, and it would solve some of the problems that prevent collaboration, validation of that data. It wouldn't solve the whole problem, but one of the reasons we're pointing to that is that it's within the current objectives and priorities of the World Intellectual Property Organization, and there's a very clear model that's already been agreed to. There's other things we could and should do, which definitely include reforming domestic law, but for the purpose of this talk, I'm going to end there and let us progress to some of the other interventions from the group. So thank you for having me, and Carla, thank you for your work administering this panel.
Thank you, Professor Sean. It was really, really clear, and including the bias, we have some issues to explain more about the bias, how to control this, how copyright can work. I read recently about a fintech app. How could they answer some loan requests based on zip code where the person would live? So many things that we should work on. Now I'm calling for it's Miguel Bastos Alvarenga. Miguel, are you there?
Yes, thank you, Carla.
Hello. Miguel is a PhD candidate in the graduate program on public policies, strategies, and development at the Federal University of Rio de Janeiro, researcher at the Brazilian Copyright Institute and NOREP. Currently researches intellectual property and its interfaces with emerging technologies such as text and data mining procedures, lawyer and legal consultant. Thank you for being part of this, Miguel.
Thank you, Carla, and thank you for the introduction. Really excellent. I will share my screen right now. Okay. Can you see it? Okay. So let us begin. First of all, thank you everyone for coming in today, and welcome to the workshop once again. As it was very aptly said, I'm Miguel Bastos Alvarenga for the Brazilian Copyright Institute and PhD candidate at the Federal University of Rio de Janeiro. And today I've come to discuss with you a little about how we could think ways of crafting copyright limitations, copyright law limitations for text and data mining in developing countries. And in this particular case, I have selected Brazil as my prime example, since it's the legal experience with which I'm the most familiar. But of course, further contributions from other countries are more than welcome. So I don't think I should extend myself too much in this introduction, because Professor Sean has already introduced the subject in a very brilliant way, and for which I thank you very much. So I would just point out some very quick points and then move straight forward to our main topic. So as said before, text and data mining are tools that seek to make sense of great amounts of data, basically via searching for correlations and patterns in large quantities of data and extracting useful information out of them, as a central part of data analysis, and by extension, as an essential part for several activities that make intensive use of data. I would give some examples such as training artificial intelligence, as you can't have machine learning procedures without data to learn from, and for conducting faster and more comprehensive research, both in the scientific field and also in journalistic research. And here I include fact-checking agencies' work on debunking fake news, for instance, as well as for developing lots of new technologies that rely on AI-intensive, data-intensive technologies and data analysis in general. So all of this underlies a prerequisite, which is access to data. So access to sources of data is of essence if we think about the whole infrastructure of text and data mining and the technologies that rely on it. And we are faced with a problem when a given project that relies on data mining, text and data mining, has to make use of content that is protected by authors' rights. So we are talking here about texts, images, audio and video files, on top of computer programs and certain databases that by copyright law are considered original in the arrangement and collection of their contents. And you couple that with a multi-layer protection system that includes technological protection measures, which are basically technological means to control and restrict access to data, such as, such a simple as a password, and then can go up to you are not authorized to access this particular piece of data, or you're not authorized to reproduce this particular piece of content. And anti-circumvention measures that are placed in law, in copyright law, to prevent, as the name implies, any circumvention or bypassing of these technological measures. All this together implies that we have a structure in which we go further and beyond what is predicted by copyright law, what copyright law would permit authors to control. And we are in a scenario where basically, if you really want to access any database that isn't really open or open source, you would need to ask for permission. And this is particularly complicated if you consider that TDM, or text and data mining, involves several acts that are covered by copyright law. And Sean has stated a few of them, such as reproduction and sharing. But I would also mention storage, adaptation, transformation, and further reutilization. Say you keep that data you have collected for a work in order to reutilize it in further works, or you share it with your fellow researchers to verify those results. And the issue with that is that most procedures that rely on text and data mining do not necessarily interfere with the market of the rights holders. So they would not affect the economical exploration of their works. So if I have a language processing algorithm, a language processing system that needs to get data from books, for instance, this would be used only for basically training the algorithm, but it wouldn't detract from sales or wouldn't stop the bookseller from selling their books. Even so, since many places, and as you have seen in Sean's map, Latin America is a particularly egregious example of that. In many of these countries, especially in the global south, we don't have provisions that allow the use of TDM for basically any kind of purpose. So that means that collection and usage of that data requires permission regardless of the purpose. And so that entails, consequently, that if we want to make use of any data, we need to seek every content owner of every copyrighted material that we might make use of. And that also means we might get into negotiations with big content owners that have a much bigger range of power. So we are basically dealing in an asymmetrical relationship where one side has lots of resources and legal backup, and the other side, which is basically researchers, small-scale entrepreneurs, we want to have access to this data, and I don't mean personal data. In most cases, it's mostly data that may even be in the public domain, but there is copyrighted data amongst all that data that is sought after. So basically, you are faced with an insecure environment for research where either you don't use a given data set because you don't want to go through the legal trouble of seeking everyone and negotiating with thousands or maybe millions of rights holders, and you risk compromising the results of your research because it will lack data and thus will probably lead to incorrect or flawed results, or you will have to go through the entire process of negotiating, which is very time costly and can have monetary costs that are outright prohibitive. So in order to deal with that insecurity, Sean has already shown that several countries have developed systems, copyright systems, that allow reproduction and usage of works for text and data mining purposes, such as Japan, United Kingdom, France, Germany, the United States, as Sean has put very well, already consider such practices of fair use in many circumstances. And all of these cases also come from the three-step test laid out in the Berne Convention and the TRIPS Agreement, where this is a well-defined case where the usage of a work by a user, by a third party, does not conflict with normal economic exploitation of the work and don't cause any sort of harm to the legitimate interests of the author or the right holder. So there is no harm to the rights holder, and there is a need. There is a fundamental right. There is a need to research. There is a bigger purpose that needs to be privileged. And in this sense, going to Brazil more specifically, the Brazilian government has already shown interest in stimulating technologies that require intensive use of data, mainly Internet of Things and artificial intelligence in general. Such that the Brazilian strategy for artificial intelligence that came out very recently this year has recognized the need to discuss a TDM limitation in the national context. But as we may see, up to this stage, we have no formal proposition on this regard yet. So we take this opportunity to discuss a few points. I start from the three-step test that I've just mentioned and utilize a few points that were laid out by Daniel Gervais on interfaces between text and data mining and copyright and big data. And those are 6 major points. I will add with some extra considerations of mine, and we'll go through these point by point. So the first point should be, should this TDM limitation apply only to reproduction rights? And as we have seen, this wouldn't be a proper solution, since as we have just seen, TDM covers a lot of acts that go way beyond reproduction. So in effect, if we restrict a limitation to just reproduction, the exception or the limitation would be rendered effectively useless. So that would be a no. It should apply to every possible right. And in this regard, it should apply to every kind of work, since text and data mining can also be applied to different kinds of archives, which entails different kinds of works. Our second point is if this limitation could be overridden by contracts. And once again, the answer would be no. First, because limitations and exceptions in general are correspondent to fundamental rights and principles, which are or should be by nature not able to be forfeited. And again, coming to the Brazilian case, the Brazilian law only allows contract override if the law expressly says so. Since we don't have that for limitations and exceptions, overriding should not be possible. But this doesn't mean, however, that no contractual stipulation controlling access and use of that work should be possible. No. You can impose some restrictions for security purposes, or those that would operate within the limits of the limitation or the exception. So anything that should compromise the normal exploitation of the work by the owner could be included perhaps in the contract. Our third point is if the material should come with a lawful source, and my answer to that would be not necessarily. And although this is a topic that hasn't reached a consensus in many TDM limitations. For instance, in the European Union, it is required to have a lawful access in the case of commercial text and data mining, whereas some other sources in the United States affirm that this is not necessary. We go with the United States in this point of view, stating that as long as the use, the final purpose is legitimate, the origin of the material should not be a question per se. So the point here is basically that if you're using for scientific research or for other uses that are allowed by limitations and exceptions, the origin, if it's lawful or not, should not be a point. Fourth is the question of sharing and dissemination of data. Could it be done, and how? And the answer would be yes. Sharing should be enabled by this limitation to the extent considered necessary for the purpose, and always in deference to the three-step test. And I cite here an analogy to the quotation right, in the sense that we already have this sort of restriction. We can quote, we can share excerpts from other copyrighted works, from other protected works, to this extent, to the extent considered necessary. Finally, our last 2 points, which should be the most delicate, but I'll try to be as accurate as possible here. The fifth point is about the purpose of the use. Should it be strictly non-commercial? And I am particularly against the idea of the usage being strictly non-commercial, because it will lead to many delimitation problems. Where do you draw the line of what constitutes a commercial use and what constitutes a non-commercial use? For instance, we have many partnerships between universities and private business or research institutes. So we have a non-profit organization and a for-profit organization working together. But in the end, the purpose, the final purpose, should not interfere with the exploitation of the protected works by the owner. So that should not be a problem by itself. And I would give another example to use it. If I make a research that would initially be non-profit and I publish a book on the results of that research, that would be a commercial use if I'm publishing, if I'm selling that book. So I think that leads to several problems, several regulatory problems that would harm the purpose of the limitation to promote innovation and to promote research. And the final point, if the limitation should allow for circumventing technological protection measures, and this could be a very touchy subject. In theory, yes, I think they should allow for circumvention, provided that, again, the purpose of the use is legitimate. If in the, as for instance, in American case law, this would be the case. And this would be easy to solve in a copyright limitation. You could lay out specific cases that could serve as examples for which this would apply. So we are talking here about scientific research, journalistic research, and so on. Because otherwise, if limitations and exceptions should not extend, let's put it this way. If circumvention of technological protection measures is not allowed, even in the case of limitations and exceptions, then there is no point to having limitations and exceptions. However, I should point out that Brazilian copyright law does not have an explicit stipulation on this regard, contrary to what we have, for instance, in the UK. And if I'm not mistaken, Japan has this as well. So there needs to be further consideration beyond just limitations and exceptions in this regard. And so I move to my final thoughts. First, a disclaimer This obviously was mostly focused on Brazilian law, copyright law. So evidently, each country will have a slightly different institutional context for which different rules will apply, and different political scenarios where the discussion of this kind of provision should be made easier or harder. So that should also be considered when we are drafting a proposal in this regard. It's also necessary to make sure that the limitation will be accessible for all entities involved, that it's easy to understand, and that all parties that are involved are perfectly capable of understanding what that entails and what can be done from this point. So we're talking not just about rights holders, but we're talking about users, and we're talking about society in general. And finally, I would add that limitations and exceptions are just one piece of a larger puzzle. We need to talk about broader reforms. We need to talk, as I said before, about how they interact with other parts of copyright law and how that interacts with other parts of law as a whole. So we are talking about data protection. We are talking about privacy issues. We are talking about several other instruments that should harmonize with that. And I think the considerations I laid out here can be perfectly applied without any sort of conflict to these other aspects. And finally, it is very important to have to discuss the formulation of these initiatives with all interested parties, not just with the content owners, but with those who wish to make use of that data for legitimate purposes, for socially relevant purposes. And most importantly, this needs to be linked to a coordinated and organized policy making from the state. This needs to be linked to a proper innovation program, to a proper innovation incentive process. I think this would be it, and I thank you very much for the opportunity.
Thank you, Miguel. Thanks for your brilliant presentation. Thank you so much. Our next guest is Professor Luca Chihu. Luca, are you there?
Hello, Carla. I'm here.
Hello, Luca. Nice to see you. Luca is PhD from the graduation program on Public Policy, Development and Strategies, PPED UFRJ, with a thesis on copyright and AI-generated works. Executive Director of the Brazilian Copyright Institute, Luca is also researcher at the National Institute of Science and Technology, Proprietas and NUREP, teacher at Positivo University, and at the Specialization Program on Intellectual Property Law at PUC Rio de Janeiro. Lecturer on Copyright at the Graduation Program on Public Policy, Development and Strategies, PPED UFRJ. Luca is also lawyer and legal consultant. Thanks for your participation, Luca. That's it.
Thank you, Carla. Thank you for the presentation. Congratulations for moderating this panel. May I share something with you? Let me see, just a minute. Can you see my screen, the slides?
Now it's okay.
Okay, fine. Thank you, Carla. Good afternoon, everyone. First of all, I would like to congratulate Carla for moderating the panel, and also thanks the professors and colleagues who are present here, Professor Sean Flynn, Miguel Avarenga, Luisa Cruz, Agnieszka Nunes, and Professor Alan Rocha. Before starting our conversation, I would just like to add something regarding the subject matter that we will be talking today, and it's related to the doctoral thesis that I've done in the UFRJ, in the Federal University, under the supervision of Professor Alan Rocha de Souza, where I dealt with outputs of AI systems, especially those that, if created by human beings, would be protected under copyright. And that's what I want to talk with you today. But first, let's start with some background information. In 1950, Alan Turing questioned, can machines think? The questioning, as seen, is not current, and as tempting as it may be, we will not delve into the discussion here. Whether they can think or not, for now, let's work with another proposition. Can machines create? And for this moment, let me propose a step back and a neutral look at the verb create, as something stripped of any subjective aspect capable of restricting such actions to a human being, and in a scenario that these machines, these systems can create something that is distinct from what already exists and has characteristics of a product that, by our legislation, by Brazilian legislation or the Berne Convention, is subject to copyright protection. Several examples show us that machines can create. Projects that seek to create a new Rembrandt, film scripts developed and recorded in 48 hours, systems that help develop drugs against COVID-19, and even tools capable of making our version in 3D or cartoon format are just a few examples of it. Therefore, today, and disregarding the subject aspect of the creation, machines can generate outputs endowed with significant originality. If expressed by human beings, such outputs would be in the scope of protection of IP rights, mainly the copyrights. So, where do we stand regarding these output systems, these outputs of AI systems? Producing this kind of results, producing results comparable to those that a human being would be capable of creatively produce, allows the same legal treatment just because the machines are developing products that does have some kinds of originality, objectivity, originality. It means that we should apply the same rules that we apply for human creations. It does not seem the case here. However, the issue is not as simple. It has been mobilizing researchers worldwide to structure solutions to balance the different interests involved, resulting in a series of models to accommodate this scenario to the existing copyright and related rights system. Before dealing with such models, however, it's important to comment on some of the aspects that support our position against the indiscriminate and full application of the rules of the current system to a. First of all, copyright was designed for humans, especially in systems based on droit d'auteur. The expression of a particular author personality is protected. The protection is based on his intellectual effort. It protects the author while recognizing the protection of his original work. Thus, regardless of the real intention behind the legal text, it is clear that a system that, in the case of Brazil, guarantees comprehensive protection for an entire life plus 70 years after the death of the author, and that does not require any formality, any registration, any fees, cannot be extended to other products without further consideration. Although, as has been already argued, that copyright was structured around the human author, the absolute anthropocentrism and the figure of the romantic author are just a moment, an episode in the history of copyright. Related rights, the protection of technical, of functional products, and the investment-oriented protection grow under the discourse of the protection of the originality and the human author. And as José de Ascensão said, we are not here arguing against the investment protection, but questioning whether such protection must be sheltered in the copyright system. Today, a new layer has been brought. The new layer brought by the AI outputs, the technocentrism, in which computer systems assume a leading role and challenge the creator role, which was previously enjoyed by human beings, impose new challenges to the law, new challenges to the researchers on this matter. We will treat such products within the copyright system and related or not. To help us on this matter, it is worth commenting one last point about the structural foundations of our system, the incentive to the offer. Here, there is no actual offer, there is no altering fact, as Anne-Marie Brady says, to be incentivized. Here, if there is an incentive, is for the investor behind a project, for the developer, or for another human figure interested in reaping the revenues of the commercial exploration of that product. Perhaps a way to illuminate the discussion regarding this treatment of AI outputs by copyrights will be to continue to assign copyrights to the human offer when the systems are used just as mere tools. In other words, low system autonomy and significant and creative contribution by a human being would allow the maintenance of the current system. We will assign the authorship, we will assign the rights to a human being. On the other hand, if the system's performance was decisive to the original content, it would be at public domain. The problem here is the 50 shades of gray, and maybe 50 is not enough. The gray area is huge. There are countless combinations between system autonomy and human interference to the point that predictability is not easy to measure. Starting with the autonomy of the system, I see that it could be twofold. The intrinsic autonomy related to the operation of the system itself, and which comprises the degree of technical opacity related to that system, how much it is possible for a human being to interfere, and how it should interfere. The how here is very important. If it is essential to understand whether a given contribution is creative or not, it is vital to understand the role of the human being in the different AI system. If in a neural network system working under supervised learning, the whole of the human exceeds the development of the system and demands greater interference in the selection, organization, and labeling of the training database, in expert systems, we would have in most cases two specialists, one of the area of expertise, for example, a physician, and the system expert who will have to translate the rules for the system. In genetic algorithms, fitness is the fundamental point, and so on. These were only three of a lot of systems which represent the huge universe of available technologies in the artificial intelligence research area. It is possible to observe the dimension of the problem when you start to look deeper in the available technologies. How much a human interferes is just another question that we must make This would be the extrinsic autonomy, how much a human being would like to interfere, would like to take part in that project. In that project would be resulting a product or output that would be or not protected under copyright. Such interference can be individual, can be multiple, can be creative and not creative. And commonly, the outputs being discussed here are the result of the work of a team composed of several specialists in information technology, arts, mathematics, among others. Not only the anthropocentrism on which the central elements of copyrights are structured until today, but also the fact that the current system does not consider some peculiarities inherent to the AI system represent factors that reinforce the inadequacy of the current legislation to fully deal with the appropriation of AI outputs. As the copyright system in Brazil is structured today, and with some few exceptions which will be addressed by Professor Alan Rocha in our later discussion, AI products generated without relevant human interference and endowed with great unpredictability will necessarily be in the public domain. Although it is indisputable that the option for the public domain would be advantageous for several reasons, including the enrichment of the collection available for access, transformation, and other forms of use, certain practical factors and possible political and institutional maneuvers to maintain the interests of the rights holder can completely void these proposals. Considering the later factors, an alternative would be the promotion of a system that would already consider the interests of the potential rights holders, would be the final part of my presentation. So, in this figure, and in addition to the public domain, which today represents the status quo for most of the AI products, appropriation models are analyzed considering the original attribution of rights and the three main recipients, namely the creator, the human creator, the owner, which can be an investor, an employer, a contractor, a coordinator, or an organizer, and the AI system itself. It must be highlighted that we also identified proposal towards a sui generis system under which the AI outputs appropriation would be regulated by industrial property law or competition law. So let's start talking about what is inside the copyrights and related rights system. The anthropocentric models, what we can talk about the anthropocentric models is that they have the original attribution of rights directed to the person of the creator. In this category, for example, we can highlight models that promote protection similar to the one verified in the computer-generated work system in the British legislation. The owner-centered models, although it could be directed to natural persons as well, must not be confused with the anthropocentric ones, since the attribution of rights is directed to the owners, to the rights holders, and not to the authors. For example, investors, contractors, employers, and one of the doctrines that is commonly said as an ideal for some authors, an ideal system for AI outputs, the works made for hire doctrine for North America copyright law. The models presented so far, each in its own way, would still be included within this extended anthropocentric paradigm. On the other hand, proposals regarding a rupture with such paradigm are not rare. These are the technocentric models, proposed to concentrate the ownership of rights or even to extend the attribution of authorship to an AI system. Under technocentric models, we discuss situations with the authorship or ownership or an AI output will be directed to an AI system. Both possibilities presuppose the challenge of attributing legal personality to AI systems and robots and would represent a significant rupture not only with the anthropocentric paradigm, but also to the very conception of humanity and our legal system. However, none of the appropriation models analyzed was able to individually and satisfactorily deal with the complexity inherent to the appropriation of AI outputs by the IP law. From these appropriation models identified in the lecture and from an internal perspective of the current copyright system, in a manner analogous to what is verified about computer programs in Brazil, and without the need for a radical break with the normative structure in force, we propose a new regulation, we propose a framework that must be developed with time. So, this said, and considering the current stage of development of these technologies and the current copyright law, we understand that the best way to deal with the AI outputs is through the adoption of a hybrid regime, which we call the meta-appropriation system. Its theoretical foundation is very much alike the one related to the owner-centered models, especially the related rights ones, since it is focused on the investment in its organization and technical features applied. With anthropocentric models, it shares similarities with copyright works and their artistic expression. And finally, with the technocentric models, they share the fact that, although they do not treat AI systems as subjects of law, they are recognized as central to the development of AI output. In turn, represents the good to be protected. Not understanding the proximity to these fundamental elements to the models mentioned above, they are not to be confused. In this proposal, the AI system will not be considered as an author, and the AI output could not be regarded as a protected copyright work as such. However, such factors do not rule out the possibility of recognizing that AI outputs and their regulation could be integrated into a copyright and related rights system. They are products endowed with objective originality equivalent to artistic expressions whose development requires investment and activities of both creative and technical nature, all elements already present in the current system. Ideally, the regulation would consist in a model within the copyright and related rights system, which could even make use of rules and definitions that already exist in the copyright law, software law, international treaties, and other regulations on the subject matter to enable, as far as possible, the harmonization with the structure on the existing system. Other structural elements that can be considered to start a conversation on a possible new model would be only property, patrimonial rights will be granted. That will be no moral rights, since that there is no offer. In fact, there is no offer, factual offer. We must work with a shorter term of protection, since the one that already exists consider the authors, his life, and the life of his successors. It is recommended that such model addresses the ownership of property rights over the AI products in different situations, considering the collective character of such projects. And also, it is crucial that any special legislation on property rights address the limitations to these exclusive rights. In this case, it can be done through reference to existing limitations, development of new ones, and the necessary amendment of the current copyright law, especially in Brazil, to comprehend the text and data mining limitation. The proposal of some guidelines on the structural elements for a meta-appropriation system represent just a small part of a vast discussion that has already been conducted worldwide, and does not intend to fully satisfy the complex scenario involved in the development of these products, of AI outputs with artistic characteristics. A lot of work remains to be done, and there is still a lot to learn, especially with regard to understanding the technical aspects of this system. For these reasons, I will end here and eagerly wait for the next speeches and panels of this important and absolutely necessary Congress. That's all I have to say. Thank you for listening. Looking forward to hear my colleagues on the matter.
Thank you, Professor Luca. Thank you for your presentation. And it reminds me that last year, Professor Allen, in the National Scientific Technology Week, he said about this, there is no space to deny ownership in all those systems, anthropocentric, technical-centric, and there's no space to deny any ownership. Thank you so much. Now is the time for Luisa. Welcome, Luisa. Are you there?
Yes.
Thank you, Luisa, for being part of this. Luisa Cruz Lobato is a PhD candidate in International Relations at the Pontifical Catholic University of Rio de Janeiro, PUC-Rio, working at the intersection of critical security studies and science and technology studies. Luisa is a junior visiting fellow at the Graduate Institute of International and Development Studies and member of the Data Network at PUC-Rio. She is also a former researcher at the Garapé Institute Cybersecurity and Digital Liberties Program. Thank you, Luisa, for being part of this panel, and welcome.
Thank you, Carla. If you allow me, I will just share my screen. I have a
yes, please.
Small PowerPoint presentation. Let me just check. Okay. I just have to authorize this. Can you see my screen? No.
Not yet, Luisa.
And now can you see it?
No.
Okay. Just a second. I think I have to authorize that on the system.
Okay, no worries.
Yeah, so I'm having some issues sharing the screen.
No problem.
Give me a sec. Originally, it should automatically lead me to the authorization screen, but apparently it isn't. And I cannot find the way. But I mean, it's not necessarily important. It was just maybe a script. But since I cannot do it, so I'm sorry, I have to go without the PowerPoint.
No problem. Go ahead.
Okay.
And thank you.
Thank you so much. So thank you, Carla, for moderating the workshop. It's also quite hard to speak of such brilliant presentations by Luca, Miguel, and Sean, but I will do my best. Perhaps I should start by saying that when Alan and Miguel invited me to this workshop, I spent quite some time thinking about how I could contribute to the discussions. Because you see, I am neither a specialist in copyright law or any kind of law, for the matter, nor I am a computer scientist or someone with any kind of technical background. So not being a specialist in AI or law, I have then come to the conclusion that maybe, and just maybe, my contribution could be bringing the perspective of someone who is, oddly enough, none of these things, but that could perhaps establish a conversation with these fields. So more like an interdisciplinary conversation. And today, my presentation today brings some of the reflections from my doctoral fieldwork that I've conducted between 2017 and 2020. And during this period, what I've done is to conduct research on 3 security apps or systems. One is an app that crowdsources reports on gunshots and shootouts. One is a predictive policing system, and the third one is an app that was developed to assist diplomats in designing international sanctions. And what this research showed me, very briefly, was, initially it was designed to focus on the work of algorithms in the global South security politics. So as you see, security is my field, my main field of research. But after a while doing field research, what I realized was that this was more challenging than originally seemed. Among other things, what was really challenging, it was not easy to find these algorithms about which we speak so much. And in some cases, what I noticed was that they were there, but paradoxically not there. And I will explain this when relating to the concepts of what an algorithm is. I have initially in the PowerPoint, I had like a small script saying what I was supposed to discuss, but then I will do the step by step in the presentation. I have paved this short route to guide us into this wilderness. Originally, what I want to propose is that we reflect on the different modes through which we can know algorithms and then controversies surrounding them. So I think that Sean already started mapping some of the controversies. Maybe I can share the PowerPoint with Leon. Maybe try to see if I can share with you. But honestly, it's not important. It's really just a script, so I can just present it like this. No, don't worry about that. Thank you. So what was it? So what I was wanting to propose is exactly to reflect on these controversies and reflect on this on how you can know algorithms, and also perhaps reflect on what this can tell us to the hard task that falls onto the hands of these participants on the workshop, and the task of also regulating them, through them, and with them. So the first point that I want to bring is that conceptually, this presentation is inspired by the field of science and technology studies, or STS, as I would call it. What STS offers us is an interdisciplinary approach to the study of science and technology in the making as well, in their practical applications. And a kind of approach that recognizes that however thick and objective these systems and practices are, they are what end up getting produced out of a complex entanglement of practices, human and otherwise, as Luca brilliantly explained. And of course, I am evidently oversimplifying the complexity of STS for the sake of time, but what I would like to emphasize are two of the questions that my field has raised, and STS as well, to the study of algorithms and computation. The first question is the question of where agency is located. Who is, I think, again, Luca's presentation brilliantly explored that. Who is responsible for again, a particular action or outcome. And the second one is the question of how technology represents the world in particular ways. In the PowerPoint, I had a very, very interesting example, but I can describe it to you, and you can, of course, briefly, I imagine that most of you will relate to other examples that you've come across, which was an Instagram post. Now, you imagine the post, and it was a video, the shortcut of a video, which basically depict a black man playing soccer. So you have a black man in the screen, and you have a soccer ball, and you have two other people which are kind of blurred. And also the image is not that, it's kind of blurred, so because of the video, so it captures the movement. And what Instagram did was to mark that content as sensitive for however reason, which we cannot know and we do not know. And since we do not know the criteria through which Instagram, the algorithm, decided to consider that content sensitive, at the same time, we know that it's not unusual for social media algorithms and other kind of algorithms mark or to be known as kind of racist, or to be racist or associated to what would be racist actions. And I will go back to this discussion once we go to discussion on bias, but I would like to highlight that episode. And the second point that I would like to stress is this idea of so my presentation was entitled Algorithms, a Perspective from a Non-Expert. And that's exactly the second point that I was going to discuss, which was the perspective of the non-expert. As most of STS literature, also the literature on expertise, will recognize, expertise involves an authoritative claim to talk about a particular subject matter. Such as, for example, when lawyers talk about law, when computer scientists talk about computation. But it's also a work related, it's also something related to the work of drawing boundaries. And boundaries that can be related to what you know, how you know, and also rituals of certification, which is basically the moment that we get our degrees and these very small rituals that we get as some certifications that tell us that we are specialists on a subject matter. And the social relevance and centrality of some algorithms is in most of the things that we do online and also offline has pushed the boundaries of computer expertise outwards. With anthropologists, social scientists, legal specialists, and others becoming increasingly interested in the topic. And with this rising interest, however, comes the problem of how to study and how to know these systems without necessarily having a computer science 101 background. And this 101 definition, which is the basic definition, I mean, there is something interesting about definitions, is that it places algorithms as a kind of finite sequence of well-defined computer implementable instructions that are used in problem solving or computation. And I had like this screenshot from my LaTeX, the code of my thesis in the LaTeX, kind of to show how simple algorithms can be. They not necessarily need to be the machine learning to which we often refer. However, One of the most interesting things of having a multitude of perspectives looking at such technical objects is that these perspectives make explicit the multiplicity that an algorithm can be, and how difficult it is to have a definite knowledge about that. So there are I think there are some citations that I can read for you that I've brought here that kind of explore that. They explore, just to introduce them, and they illustrate that the case that even for technical people, sometimes algorithms are not, it's not clear what an algorithm is. So I have this citation from an anthropologist called Nick Seaver, and he did a research with a music recommendation system, and he kind of spent some months on a company that was developing these systems. And what he basically concludes, and he says, I quote, that he speaks about ethnography and how it kind of throw analytic frameworks into disarray. And he says, I quote, after setting out to study engineers specifically, I realized that many more actors shaped the systems these companies built. Eventually, I interviewed half of the employees of a recommended company that at the time employed roughly 80 people. These people's jobs ranged from summer intern to CAO, and from systems engineer to front-end web developer. All of them, whether technical people or not, were part of the production of algorithms. But in the office, the algorithm seemed to be nowhere in particular. And then he continues saying that one senior software engineer that he interviewed told him that her training on algorithms in theory was irrelevant for her work in practice, because algorithms in practice were harder to precisely locate. And he quotes her, "It's very much black magic that goes on in there. Even if you code a lot of it up, a lot of that stuff is lost on you. The algorithm here was a collective product, and consequently, everyone felt like an outsider to it." So Nick Seaver's anthropological research kind of shows the difficulty of locating these actants, if I can say like that. And this uncertainty that surrounds the algorithm as an object of inquiry all will bring me to my third point, which is the controversies around algorithms. And perhaps I would say the most controversial kind of algorithm nowadays is being discussed right now, and is the machine learning kind of algorithms, supervised or not. Machine learning algorithms are trained to classify and predict a range of things from our consumer habits to crime forecasts, as I suppose that many of you are already familiar with them. And the accuracy of these predictions and classifications depend on which algorithm and how it acts, and from which depends on the data set on which the algorithm acts and from which it learns, as Sean and Miguel and Luca have been emphasizing so far. And even when it is the case that these systems are unsupervised, the truth is that their work is always in collaboration with humans. There is always a degree of human judgment involved in designing the algorithm, adjusting the priorities, defining its features, collecting and pre-classifying training data, and structuring this data, as well as adjusting thresholds and parameters, among other necessary steps for programming and modeling. At the same time, it is very difficult to establish the linear causality between the intention of the people designing the algorithm and what it ends up doing. So the whole source of controversy that we have. And as Kate Crawford notes, algorithms may be root-based mechanisms that fulfill requests, but they're also governing agents that are choosing between competing and sometimes conflicting data objects. And when we're looking at the people programming these models, and this all the reflections that I'm bringing from my case studies, we also see that they are no experts, to the extent that they are working with a foreign object to them as well. They code an algorithm that is always embedding particular assumptions and worldview or worldviews into computation. And this includes, for example, assumptions of policing practices and some racist assumptions about who, based on social background, skin color, is more likely to commit a crime, as well as assumptions from criminological studies and criminology about the near repeat events, the likelihood of a crime to happen in a particular window of time and space. Risk factors affecting the likelihood of a particular crime to happen, among others. Which, of course, will lead us to the problem that Sean introduced, which is bias and accountability of algorithm systems, which becomes especially complex when we realize that bias and opacity, there is our inability to understand how our Instagram algorithm decided to classify a video of a black man playing soccer as sensitive. These are not only data problems. These are also problems of designing a model and choosing the priorities of computation. Is this priority privacy? Is it test set accuracy? Is it robustness? We don't know. As Sarah Hooker puts it, training a parametric model is akin to have a fixed amount of materials to build a house with. If we decide to use more bricks, building a bigger living room, we are forced to redistribute the other number of bricks available for all of the other rooms. In the same vein, when we prioritize one objective, whether that be test set accuracy or additional criteria such as compactness or privacy, we inevitably introduce new trade-offs to these algorithms. Besides that, besides the issue with data and besides the issue with the model, there is also other forms of opacity, such as institutional opacity, when we think of trade secrets and copyright protections on algorithms. Technical, such as when we open source a code, but even like open source code may become too complex for experts to understand. And this is called like the dark gray box. And also semantic, which is part of the different modes through which humans and computers think and understand things, including how we make, and the question of how we make computational processes understandable to humans. As Jenna Burrow notes, the opacity of machine learning algorithms is challenging at a more fundamental level. When a computer learns and consequently builds its own representation of a classification decision, it does not do it so without regards to a human comprehension. It does so actually without regards to human comprehension. So my idea was to leave you with these open questions and reflections. And of course, not to respond to any of these questions and not to propose any solutions, but hoping that this may fit into the discussions that we have been having so far, and maybe spur into very interesting questions to both the presenters and the audience. So I thank you very much for your attention, and apologies for the small technical issue.
You're welcome, Luisa. Thanks for your presentation. We are still waiting for Agnès Canoes, researcher from Warsaw University, and we are going ahead with Professor Alan Rocha. Professor?
Hello.
Hello.
Good afternoon. Seems everyone. So I'm supposed to close off the meeting. Agnieszka is not here yet. We're not sure if she'll be able to make it. But in any case, I will do some of the words that I've been thinking of and what actually pushed us and propelled us to organize this panel and to bring out these questions to the broader community, because it's usually the copyright questions. Both copyright questions and AI questions remain very secluded to a very specific areas. In law, like some people talk about AI, very few people actually talk about copyright, discuss or do research on it. And many fewer people actually bridge those research and do start a dialogue between what means AI produce. AI produced goods that look alike human creations and copyright. What would be the implications? And I have a few considerations about it, considering what everyone has already said in advance. One of them is that generation of creative-like products by autonomous AI systems is already possible. It's being shown in all different areas of artistic production, and not only as a tool, an ancillary technology to creation, which is also used, and to which is also a very great use. But in itself, as the producer of an autonomous producer of equivalent products. And the reason why I'm talking about equivalent products is because the fact that an AI system produces a painting or a painting like, music like, a screenplay like, a story like product, it doesn't really mean it will be considered a literary work, it will be considered art in general. Because for something to be considered art, it must be embedded in cultural meaning, in substantial cultural meaning. That's why a specific artifact, object, concept, idea, or whatever is made valuable or not valuable. And I mean socially valuable and eventually economically valuable as well. It really depends on the cultural web where it's entangled. There is no art outside of this cultural web. And this cultural web is so far as consciousness itself is not yet, self-consciousness at least, is not yet developed in living species or types or systems or whatever we can call it. Since it's not yet, the cultural formation and the construction of this web of meaning is not yet expanded to other beings, it really depends on us how much value a certain AI produced good that looks like human art would be valuable. And even if that will be considered art itself, to the point as being sold as art, as being dealt as art, as being negotiated and referred to as art. That really doesn't depend on what lawyers and authors alike think. It really depends on the wider social concept and vision of what these products should be considered as. You know, in a very short historical time, we've come as humans, as human species, to believe that we were so special to the point that we were the only ones to use technology. And by technology, I also mean tools, like tools, not technology, and all different technologies, having control of fire and so on and on and on. Would it be like part of the gender, like Homo sapiens, or even more specialized Homo sapiens sapiens, which would be us. But in fact, since the 60s, we've had a lot of scientific steps that have pushed the boundaries of what human really is. We thought like using tools was a differentiation, an element of difference between us and other species. We also thought that language was our idiosyncratic characteristics. We also thought at one time that even culture has been under criticism in terms of species specifics, of being species specifics. So basically, since late 50s on, we have been pushing the boundaries of what humanity really is. And one of the things that was really long lasting is the idea that we are the only ones to create art or create art like products, art or aesthetic um, products or goods or artifacts. But in fact, we can see that we can not replicate, modulate uh, those products. Machines can modulate those products. And what really needs for those products to be considered art or to be considered worth of protection by the existing copyright system or author rights system is that us humans decide that that sort of product is worth to be valued, considered, and labeled as art. Once we as humans decide that, then those products become art. And if they become considered art, they will also uh, come a long way to be considered a work of authorship. And being considered authorship, that's one thing. And I think we're still not there yet. We're still not there on the realization that, well, maybe what's really special about us is not really the possibility of creating art, but actually the possibility of valuing some artifacts and products as art and attributing to it such a high social status. That could easily be done to other equipments, but to other artifacts. But until we, the receivers of these artifacts, uh, collectively evolve or decide for that, it won't happen. On the other hand, it's not entirely out of the box to consider that some aspects of AI created materials are already protected under existing author rights and neighboring rights legislation. And obviously, not all of them, but I'll give you one example that enters, in my perspective, into the protection of copyright under the contemporary statutory regulation of author rights, at least in Brazil, and I'm pretty sure in other parts of the world as well. It is the fact that AI produced lyrics or music once recorded either by an artist or by anyone, basically, it becomes a sound recording. And once it becomes a sound recording, it is protected as such. So, although AI produced music is definitely not yet protected by author rights or copyright systems all over anywhere in the world so far, some they are awarded some protections, and specifically so far in the case of sound recording, which does not distinguish between human produced lyrics or music and AI produced lyrics or music, as much as it does not differentiate between human produced sounds and animal produced sounds, like bird songs, whale songs, and so on. So, the same way that we have come already some steps away, if not many, from the anthropocentric perspective or base from where contemporary copyright and author rights departure, we have come to attach to this core protection a series of related rights, which one of which does apply to AI recorded music. I mean, AI produced but recorded music. And we see from there a specific window where there could be an extension to protect all sort of AI produced art equivalent products. This is one thing. And I think that's something we need to reflect further on, because most of the reading and the writing that there is about really denies the possibility of existing any sort of protection under current copyright law. So this is one side, is the output side. On the input side, I will refer to the Professor Sean, Miguel, and Luca Chihu, Miguel Alvarenga and Luca Chihu, when they mention the relation between research, right to research, especially contemporary research, not only academic research, but also innovation, research for innovation, applied research for innovation, as in the case of most AI, and data and text mining, and data text mining possibilities. So combining research rights, the possibility of developing AI systems, training the AI systems, and the need for an openness within copyright law all over the world, and most especially in the developing countries, which are lacking way behind in the regulatory system structure, in a way to introduce into copyright a data and text mine exception, which would allow the development and the training of machine on a much better and broader amount of data and set of data, diverse set of data. Not only would improve its training, but would also help to gap the technological divide between developed countries, and developing countries, especially when it comes and develops its own technology that applies and it's trained and will fulfill demands that come from their own needs. So, and especially so, these countries, they have this huge door, this very strong fortress around copyright and author rights protected materials. And we, by doing that and not having the limitation, the equivalent limitations and exceptions, we are not allowing the flux of information to be actually captured by research and being used and applied for the development of intelligent systems. So we have two problems. One on the inputs, where copyright actually blocks the development of AI systems if we look carefully at it in most places. On the other hand, we have how to regulate the output. And what we are proposing, what I am proposing, also together with Luca and Miguel and others that have come to this panel, is that we do need broader and more wide exceptions to copyright for research and specifically for data text mining on the one hand. On the other hand, we need to rethink our considerations about what kind of protection and regulatory measures we will do and attribute to products that are equivalent produced by AI systems. So with those questions still open for debate, I end here my presentation, and I will pass on the word to Carla. I mean, if she is still here, and maybe our next guest has arrived. I'm not sure.
Thank you, Professor Allen. Thanks for your presentation. The researcher, Anies Canus, is still not here yet. And we will open for debate for more time to make her arrival here.
Is Sean and Miguel and Luisa there?
Thank you, guys.
Hello.
Well, we have some questions. There is one direct from Professor Sean. The person is asking to explain more about the bias, the inputs and outputs, and the bias, and and how can copyright helps this?
Okay. So one of the problems of having outputs of AI that's not representative of the life that we know it everywhere is because the inputs into systems are not necessarily drawn from the life we know it anywhere. So I think the self-driving car AI doesn't stop for a kangaroo is a good example. So if you only train your car to stop for people and dogs and cats and things with 4 legs, and then it sees a kangaroo and it doesn't know what to do with it, so it just keeps going. Because computers can't decipher it. You know, they have to be trained with actual examples of things in order to learn from them. So if you remember the map I showed where, you know, it's only about 25% of the world's countries permit the reproduction and sharing works, and something like maybe half of the countries permit something like reproductions without the sharing, then you're excluding at least half the countries from contributing to those databases. And if you don't have the sharing, you're preventing all researchers from going, you know, underneath the hood and basically examining what is it that's feeding the AI that leads to these outcomes. So if you had a world in which there were broader research rights, it wouldn't solve all the problems. You could still have bias, you know, in those systems, but you enable more data to come in, you know. So one of the common phrases in the environmental movement is the solution to pollution is dilution. The solution to having a little bit of bad data is to have lots more data to offset the bad data. And so you want as much data going into these processes as possible, and the right to be able to check it to control for bias on the outside. There's still lots of things that I don't think should be done by computers. You know, there's examples of, for instance, you know, AI systems that predict crime. And then all they're looking at is who's in jail. So what do you find? You know, you find that they think that people with certain kinds of attributes are more likely to fit crime because that's who we put in jail. But that's not actually measuring crime, because we don't have a facility to measure crime. We can only measure who's in jail. So you're measuring the outcomes of a process instead of the income. So, you know, you have to have systems to decide what kind of questions we want to ask AI in the first place. But once we're doing that, you want to have as much data as possible going into it, and that is a direct function of copyright. Hope that helps.
Thank you, Professor Sean. And there is one for Professor Allen to explain more about neighboring rights.
Okay, very quickly. Neighboring rights are not specifically copyrights. There are like basically 4 different categories under neighboring and related rights. One is for the artists themselves, the singers, the interpreters, and so on. Mostly the singers at the beginning, but also interpreters, actors, and so on. Dancers, and there you go. The musicians that actually go on the bands, the ones that actually play the music themselves. So you have the singer and you have the musicians, the band that composes. Those are also protected by neighboring and related rights. In Brazil and a lot of alpha right countries, a lot, you know, mostly Europe and Latin America for sure. A third category is by broadcasters, which basically buy, and that's because of the investment they make in actually transmitting the copyright work. So once we have that, there is a gap there. There is a change there. You have the alpha rights, then you have the neighboring and related rights, And within those rights, you have also a division, one that's centered on the individual, the artist, the person that's actually representing the work, the creative work, and also that adds some layer of creation for sure and expression. The second one are the musicians that actually act upon the lyrics, the music, and actually make and produce the sounds. They also add another layer of creativity. But then you have two others within the neighboring and related rights. One of them is for broadcasters, just for the fact that they transmit the work, like the film, the music through the radios, and so on and on and on. And the second one is for phonogram producers, for the recording, for the investment, the technological, the know-how in actually making and producing a recording. Okay, simply by that. In Brazil, for example, it's only for the phonogram recordings, like the sound recording. And the sound recording does not need to be a recording of a lyric or song by itself that was human made, for example. It can be any recording. It could be, and it is, recording of animal sounds. If you ever seen any of the nature documentaries, they are full of sounds. Those sounds are recorded. Those recordings are protected. So it doesn't matter where actually the sound comes from. The recording itself is protected. Sure, I can go myself and actually record the birds, the whale, and the dolphins. There will be two recordings, which could be similar or not similar. I don't know if you could say that the birds were doing plagiarism, although they do a lot of imitation. And that's part of the process that they integrate within their species. But also, AI created music once recorded by the system itself, by someone else, by an artist that could decide, yes, I will record this lyric, and this set of sounds and make that a music. And sure, that recording is protected. So I don't think we should say that there is no room for any sort of protection for AI outputs, because if it is a sound recording, even if the recording is of AI produced music, that recording will be protected itself, which doesn't mean other people couldn't make the same recording. They could, because the author rights are not protected in that case, but just the sound recording. So there is a window there that we could maybe explore for possible regulation of AI outputs within the equivalent of creative expressions.
Thank you, Professor Alan. Thank you. There's another question for Miguel to explain more about interfaces with personal data.
So this is quite a difficult question. Most of what I've been presenting is mostly related to non-personal data. So it's basically copyrighted material or some other materials that may be in the public domain or otherwise do not relate exactly to personal data. But there might be cases where there is some sort of materials that are personal, that involve personal information, or that are directly linked to another person. In that case, I think that any limitation on this regard, so that we do not step over the GDPR, for instance, or the laws we have in Brazil for data protection, it should consider that there should be a boundary. If we build a limitation or an exception, we need to stress that out in the provision. So for instance, it could happen if we want to use some data from Facebook or some data on Twitter. This could involve someone. If we want to use a video archive that, for instance, features non-authorized recording of a given person, then this sort of regulation should still apply. And so any provisions regarding protection of personal data should also apply, but should not interfere with usage of copyrighted works. So I think in this case, a simple addition to the limitation should be able to suffice.
Thank you. Thank you, Miguel. And now I'm asking Professor Alan for final thoughts.
Okay. Well, I'd like to thank everyone for taking part. Sean, Luca, Miguel, Luisa, and special thank you for Carla for brilliantly conducting this panel. The presentations will be available at the NUREP YouTube channel. We also invite you to follow us there. And you're going to also very soon receive some information about the website and all the beginning of the activities of the Brazilian Copyright Institute, which will be carrying on this research, not only in an academic sense, but in a more applied sense. So we're going to be very eager to talk to all of you interested in this subject, and also both AI, copyright, and especially the bridging between both AI and copyright. So I'd like to thank you very much for the presentation, for the time, and say that we are available. Just get in touch with us and we will keep on the conversation. Thank you a lot. Have a good evening.
Thank you.
Or afternoon or morning. Depends
Thank
on where you are.
And Luisa, your final thoughts, please.
Yes, thank you so much, Carla. Thank you for the brilliant moderation, and also thank you all the participants for the presentations. I've learned a lot. And Alan, thank you so much for inviting me. I do hope that we keep exchanging ideas about this more anthropological experiences about algorithms and big data. So yes. So thank you to all of you who watched this presentation. Because, hope you liked it. So,
as everything that is online and live, I have information from our technical team that Agnieszka News just entered. She's just here. Agnieszka, you there?
I'm here. Nice to see you. All of them. I don't know if it's still possible to present my speech.
It is. We knew you'd be late. Don't worry. Miguel told us. We've been following you. We've been hoping that you arrive. We only have 15 minutes. We actually did give the closing thoughts, but no, we will be able to present. We want to hear you. So can you do that in 10 minutes, 12 minutes? Do you think you can do it?
Yeah, I will try to do it as smoothly and as fast as it's possible.
That's fine, but don't need to rush. Just give your message and welcome. Well, first of all, welcome. You're welcome to come here. We know it's like these different GMT. It's like a lot of times all over the world.
Yes.
So we know you're rushed. We're all like in a rush, but you're very welcome. So I will pass on to Carla, and Carla will follow you. We will be watching you, but we will have our cameras off so you can present and so on. Well, very welcome.
Okay, thank you very much. Okay,
Hello,
so a topic of my.
Hello, Agnieszka.
Okay.
Welcome.
Thank you.
Agnieszka is a researcher from Warsaw University, and I will let you introduce yourself, and that's it. Okay.
Okay, so my main interest is the relation of copyright it's an artificial intelligence from many legal perspectives, especially competition law and intellectual property law. And that is the reason why I would like to today shortly present the topic related to the AI's authorship, because artificial intelligence is the popularity of artificial intelligence is undoubtedly growing in our societies, in our economics. So it may be crucial to regulate the artificial intelligence also from the perspective of law, from the legal perspective. And one of the most popular or welcomed concept of regulating artificial intelligence is, in fact, regulating AI from the perspective of copyright law. And that field may be, that topic may be in particular interesting because of the fact that artificial intelligence is nowadays generally qualified as a computer program, which in many jurisdictions is also subject of copyright protection law. So in case in which AI creates a work which may be a subject of copyright protection law, we have a situation in which one subject of copyright protection law creates another subject of copyright protection law. And in that cases, the copyright law is not not applicable. Then that's the reason why the additional regulations from the copyright protection law may be necessary in that case. And consequently, the aim of my today's speech is to analyze, consider, and assess the possible options of such regulations. Of course, the suggestions which I mentioned today are the chosen few ones, because the concepts of AI's copyright authorship and copyright protection law the scope of ideas is very wide, so it's not possible to mention all of them. And the main goal of my today's presentation is to consider whether works created by artificial intelligence shall be qualified as the subject of copyright protection law on the same basis as it is in case of works created by a natural person, and whether AI shall become an author itself, and if so, how that question and that issue shall be regulated. And before moving to that topic, I would like to also briefly analyze definitions of artificial intelligence, because as we all know, the definitions of artificial intelligence, especially from the technical perspective, are the scope of the definitions are wide and various. So however, the topic of AI's authorship is mainly legal topic, especially from today's perspective. So I would like to stick to the legal definitions which are already implemented or they are suggested. And first definition is a definition of AI system, which was proposed by European Parliament in the document called Report with Recommendations to the Commission on a Civil Liability for Artificial Intelligence. And in that, according to that proposition of AI system definition, AI system shall be a computer system which displays any signs of intelligent behavior during the process of data processing or decision making. Such AI system shall as well show certain degree of autonomy and operate as a part of the software or hardware. And in my opinion, that definition reflects briefly the most important features of artificial intelligence. However, there are also some inaccuracies in that definition. For example, for me, the biggest inaccuracy of the AI system is the wording intelligent behavior, because it's impossible to briefly and to precisely define what intelligent behavior really is. So that question, that issue shall be precise case by case in practice, whether that definition will be implemented in European Union law. And the second definition, which is mostly similar, but is also wider, because it doesn't cover only artificial intelligence. It is a definition of automated decision system implemented in Algorithmic Accountability Act of the United States. According to the definition, the automated decision system shall be a computer process, including one based on machine learning, statistics, or any other data processing technique, or artificial intelligence itself, in which the decision with an impact on the consumer situation is provided. So this is the scope of artificial intelligence, also definition of artificial intelligence, also for today's speech. And moving to the topic of AI's authorship, I would like to focus on two cases when this authorship may be applied, because the concepts of AI's authorship are so various, so different, that it's impossible to define and to analyze all of them. First situation is a situation in which AI is primarily and initially created to create, or maybe we can also say produce, certain types of works, and that types of works are artificial intelligence creates only that types of works which are, let's say, on a model of what it has been programmed to. And the second situation is a situation in which AI creates works more or less on its own, for example, as a so-called side activity of its primarily of the activities in which it has been programmed to primarily, or in a more sophisticated cases, but not yet, I think so, not yet applicable, that AI creates work which may be a subject of copyright protection law on its own. And in the first case, it is when AI creates only works which it has been programmed to. The solutions of regulating AI's authorship may be two. In first case, we can. It is possible to grant all economic and moral rights to the author of AI, and AI will not gain any copyright laws in that case. And second possibility is to grant AI with authorship rights, and that can be done in two ways. We can grant AI with copyright rights, let's say the same or very similar to the one which are granted to a natural person, who become an author. Or it may be that concept of authorship of AI may be constructed differently. But I would like to, in that case, I would like to speak in favor of granting copyright. In favor of granting copyright law rights to the author of AI, because it was the person who has the biggest impact, on how that work was created and how it looks like. So that is the possible solution for me, the best solution in that first case. And in second case, it is when AI creates a work on its own or as a so-called side effect. There also can be two solutions. It is granting AI with copyright, with authorship rights as it is in the case of natural person. Or the second is modifying the concept of authorship, especially for artificial intelligence. And when we would like to grant AI authorship the same as it is with in case of natural person, it especially when we would like to grant AI with economic rights, it may result in a great emancipation of AI in legal system, but as well in societies and economics, because artificial intelligence will gain its own assets. It shall be somehow able to decide what to do with its own assets, and this situation may lead to the losing the control over artificial intelligence, in my opinion. So that concept of authorship shall be modified, redefined. In the case of artificial intelligence, so I would like to speak in favor of a solution in which all economic rights will be will be assigned to the author of artificial intelligence. It is a natural person, and that solution may allow keeping control over AI. And in the field of economic authorship rights,
3 minutes, Agnieszka.
Okay, 3 minutes. Okay, perfect. In the field of moral rights, I would like to speak in favor of redefining moral rights in so-called duties or obligations. For example, in many jurisdictions, it exists right of the author to decide how the work shall be published, about first publishing of the work, and how it shall be done. For example, whether the work shall be published under the name of the author or anonymously, and that moral right may be transformed into the duty of informing that the work were created by artificial intelligence. And the proposed modification of the concept of authorship for artificial intelligence, which I've already briefly described, may, in my opinion, help or allow keeping control over artificial intelligence from the one side, and from the other, it will legally constitute that artificial intelligence may be an author and is able to become an author. So thank you very much for that for the possibility of that brief presentation.
Thank you for your presentation. And as we were doing before Agnieszka entered, Luisa was saying her last words, but Luisa is not here yet. I think she had to leave.
Unfortunately, because of the whole Congress rules, we will not be able to really go much further. It is too bad we just could talk now, Agnieszka, because you brought had a lot to do with actually what was said before, and it would be wonderful to have like a further discussion on this, especially Luca's work, which basically he completed his PhD last year, specifically dealing with that, working with that. And I agree with you that we need to take a step further towards legal personhood of AI systems. This change of whether it can be an author or not really depends on whether we're going to attribute anything like personhood and to what level, to what sense. And I think we're not ready for that yet. I think humanity is not quite ready for that yet. But I'd like to thank you. And unfortunately, we can't now have, this, to go further on this discussion, but we'll get in touch and maybe have another panel or something and bring more other people together so we could further that discussion, because it's a very exciting discussion all over the place. So, Luca, do you have anything to say? Miguel, Luisa?
Just thank you all.
Yeah, thank you so much for everyone watching. Yes.
And you're very welcome. And again, thank you again for the presentation. And thank you everyone for taking part. And thank you, Carla, for moderating it for this 2.5 hours that we've been on. And I'd like to thank also the people that have been following and watching us on YouTube. The recording will be available. Probably will take 24 hours at least to do so, 24 hours or so. But it will be available on the same channel, so everyone can watch. And you're going to be there also, Agnes. So good thing that you arrived before we closed off. So you have the proof of your presentation as well on YouTube. And you'll be able to watch the other ones too. So you can see how much they dialogue among themselves. So, and have a good day, everyone, or a good night, depending on where you are. And we will probably meet sometime soon. Bye-bye.
Bye-bye.
Bye.
Hi, everyone.
Thank you. Bye-bye.